Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, March 31st, 2026. The time is now 10 a.m. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this morning include Ms. Reyes, Mr. Lopez, Mr. Cordova, Ms. Noriega, Ms. Ramos, Mr. Hernandez, Ms. Rivera, and Ms. Lozano. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez, Ms. Flores.
First in person, Counsel Antonio Figueroa, page 3, number 6.
Patricia Ornelas versus Jose de Jesus Ornelas, cause number 2026 FLB 152C3. Court marks Mr. Figueroa present in person. Mr. Martinez King present in person. Both counsel are present in person. Are you Patricia Ornelas? Court has heard yes, sir. Welcome to court, Ms. Ornelas. The court marks you present in person. The person to your left is your lawyer. Are you Jose de Jesus Ornelas?
Yes.
Court has heard yes. The court marks you present in person. The person to your right is your lawyer. This is the fourth setting on a TRO. Mr. Martinez King, Mr. Figueroa.
We're here in our motion for temporary orders. We have some difficulty.
Inaudible.
You're not on the record. Speak into the microphone, please.
Oh, they can't hear me?
No, nobody can. Go ahead.
Okay. Tony Figueroa for Mr. Ornelas. We're here in the temporary orders for Mr. Ornelas. We had some difficulty serving her, and also she's pro se, so the court requested that we personally give her notice of the setting, and we're here for that today. The issue before the court is very, very simple. Basically, we're asking for the use of the home, use of a Jeep, that the court may have a
You're not on the record anymore.
a mutual restraining order, and that my client used to work with his wife. They had a employment with some company, and that they would split the check. Then as soon as she filed for divorce, she stopped giving him his share. They're basically janitorial services through some company that they're employees. So as soon as she filed for divorce, she stopped giving him his share. My client is disabled, he's elderly, and doesn't have any source of income except what he would receive. They would basically split the check between him and his wife. And that stopped as soon as she filed for divorce. So we feel that she violated her own petition and the standing order of the courts here in Webb County by stopping him from continuing to be gainfully employed and working there where her wife works also. So those are the issues.
And on those issues, have your conversations with Mr. Martinez King led to any headway?
But I believe they have no objection as to the vehicle. The vehicle, as to the use of the home, I don't think they're in agreement, and I don't think they're in agreement as to the paycheck.
Mr. Martinez King.
If I may, Judge, so there was, at least I don't remember seeing any mention of a paycheck on the temporary orders. The only other item that was on there that we are disputing is the exclusive use of the home.
I guess, Mr. Figueroa, your client is requesting exclusive use.
Yes, sir.
Mr. Martinez King, and your client is requesting exclusive use.
No, Judge. They're okay with the standard they have right now. They're both living in separate bedrooms. Um, but as far as I understand it, he's wishing to get her and her family out. But
Sure.
Ms. Ornelas' son lives there. He's an adult, he's married, and there's 4 children there in the house. So there's 6 people living in addition to them too. The children are 8, 10, 12, and I believe 15 years old. So it's very difficult for my client to be at peace. He's being ostracized, he's been treated very poorly by her and her family. It's the environment of being there in the house with them is very toxic, and it just doesn't feel well, and they do everything to annoy him and to molest him.
Mr. Figueroa, no dispute that this home is marital property?
No dispute as to there's a
Yes or no?
there's no dispute.
Same question, Mr. Martinez King. No dispute that this home is marital property?
no dispute.
Mr. Figueroa, so first agreement. Mr. Figueroa, how many people reside at the home?
It's 8.
Eight of those, right? 8 of those, 2 of those are the parties. The other 6 people, who are those persons?
The petitioner's son and wife and 4 children.
Mr. Martinez King, true or not true? 8 persons total, 6 not including the parties. The other 6 are your client's son, wife, and children?
That is true, Judge.
All right, second agreement. Mr. Figueroa, ostensibly petitioner's son and wife are adults.
Yes, sir.
True or not true?
True.
All right. So I guess, Mr. Martinez King, I'm going to give you all some time to talk. I've already marked this case as a first contested matter, but what I need to hear from each, what y'all need to flesh out is, Mr. Martinez King, what gives these 6 other persons a superior right of possession? Right? So, I mean, I guess if you're a part owner of the house, you can ask that people be excluded. I mean, they're not owners. And then what I need to hear from you and your client, Mr. Figueroa, is what elements, I guess all the elements have to be met, right? But do all the elements exist in this case to allow the court to make a finding for exclusion? I know you both know what those are, but talk to each other about those things. On the one hand, what gives all of these persons a right to be there? And on the other hand, what allows the court to exclude the petitioner? All right, so talk about these things, and this is the first contested matter. Good luck to all.
Thank you.
Person counsel Jose Rodriguez, page 1, number 1.
This is Angel Darian Benavides versus Jocelyn Leticia Liendo, cause number 2026 FLA 90C3. Court marks Mr. Rodriguez present in person. Ms. Soto, are you present?
I am judge on Zoom, and so is my client.
Welcome to court, Ms. Soto. The court marks you present by video conference. Good morning, Mr. Rodriguez.
Good morning, Judge.
Are you Jocelyn Leticia Liendo?
Oh, what happened?
You are Jocelyn Liendo?
Yes. Can you hear me?
Welcome to court, Ms. Liendo. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present. Angel Darian Benavides, are you present?
He is not, Judge.
Into the microphone, go ahead.
Yes, he's not present, Judge. We've conferred with counsel. He's in the military. So he's currently out of the country in training.
All right. Well, this is temporary orders, motion for the appointment of guardian ad litem for the child. Mr. Rodriguez, Ms. Soto, have you had a chance to confer on these items?
We have, Judge, we have a tentative agreement. I did get some wage information from Mr. Rodriguez right now about his client. It's a W-2. What I wanted to receive is his military pay, his current military pay, to see what his basic housing allowance was. And if it was any different than now that he's deployed or active.
This is what you're requesting. Is there an agreement as to its production?
Yes, Judge. We
No,
have
we
no
had.
issue.
Okay.
It's just a little difficult getting documentation given the time difference. But yeah, there is no issue as far as the temporary orders go, as far as him paying child support under the statute. We just need to get the documents together.
Understood. So what is the request here for this setting, Mr. Rodriguez and Ms. Soto?
Judge, I believe we're in agreement for the temporary orders submitted by the respondent. We submitted a non-objection notice that lists all the various conditions, one of which is visitation by the petitioner's mother, paternal grandmother, through Safe Haven. And that'll be, I guess, the standard visitation schedule.
Ms. Soto?
And that's correct, Judge. So they did send me that non-opposition, but just to clarify, Safe Haven does not do a standard visitation schedule. Both Mrs. Liendo and paternal grandmother would have to register. And Safe Haven gives them availability, and it's typically an hour or a 1 hour visit on a day that Safe Haven is available. So it won't be standard visitation schedule.
All right, so it sounds like you have an agreement, so I can just set you down for orders due on that, on the temporary orders. So the temporary orders are due to the court honor before.
April 27th at noon by submission.
Now, as to the request for the appointment of a guardian ad litem, have you had a chance to confer with each other?
We have, Judge, because this child is young and has not had much contact at all with his biological father or paternal grandmother. That's why we're doing Safe Haven. My client and I are in agreement to hold off on requesting an ad litem until we see how those supervised visits go. We may re-urge it later, but I'm not urging that motion now.
All right, so we're gonna take, and any objection to any of this?
Well, we did file an objection to the appointment, Judge, but we're not obviously urging that now since they're not requesting that.
That motion will be removed from the court's docket, not urged and opposed. So these temporary orders are due on April the 27th. Ms. Flores, give us a final pretrial hearing and final hearing, beginning with the final pretrial hearing in June. Wait, before I do, Ms. Soto, how many children before the court?
One, Judge, one
Eight.
child. 3,
And gender?
male.
All
It's a boy.
true statements, Mr. Rodriguez?
Yes, Judge.
All right. 3. Same thing, but it can be even earlier. So May, June for final pretrial?
I would like June, Judge, please.
Any
To give us
objection?
some time.
No objection, Judge.
June, Ms. Flores?
Yes, Your Honor, final pretrial would be set for June 16th at 2 p.m.
Give us a final hearing in July or August.
July 28th at 2 p.m.
Any objection to any of this, Mr. Rodriguez?
No objection, Judge.
Ms. Soto?
No, Judge, may I just ask, when can I get that pay stub information? If I can have it before the 27th, so we can submit it with the temporary orders?
Yes, I'll try to get that before the 27th, Judge.
Well, give me a definitive date so that I can put it into the record, and then it becomes binding and enforceable, give yourself sufficient time. There's about 4 weeks. How much time do you need?
Yes, Judge, it's just, like I said, the time difference is difficult for communication, but I'd say a few days before the the 27th, just to give me enough time.
I reckon maybe it'll be the week before.
All right, I'm gonna give you 21 days. The military pay information is hereby ordered due April the 21st by 5 p.m. If you want an order to that effect, Ms. Soto, file it. The court will sign off on it.
Yes.
And that
What-
gives you something to talk about your client with Mr. Rodriguez. I know there's a time difference, but that's 21 days. No matter what time zone he's in, it's still 21 days. All right, anything else on this case, Mr. Rodriguez?
No, Judge.
Ms. Soto?
One last thing, Judge, I would like the order to include that the payments will be made either by Zelle or Cash App, since military will not garnish the wages. Mr. Benavides has to send a payment.
And just to add on that, Judge, so there currently has been payment for about I believe since November 2023 with the use of Zelle, and it's been about $250 bi-weekly, $250. So if anything, these documents will I guess accurately portray the 20% under the statute further, but there's already been payment being made
How is the payment being made?
through Zelle.
Any objection to that continuing? Endo, do you have any questions for the court?
No, Judge.
Keep in contact with your lawyer. Mr. Benavides will do the same thing. I wish both you and him, and more importantly, I wish your son all the best. Good luck to all three. You're excused.
Thank you. Thank
Good
you,
to see
Judge.
you, Mr. Rodriguez.
Thank you, Judge.
Have a good day.
Likewise.
Next in person, Council Ruben Arce, page 3, number 7.
Magdalena Villarreal, this is in the matter of 2026 FLC 261C3. Good morning, Mr. Arce. Very good. Thank you. Court marks you present in person. Speak into a microphone and tell the court, are you Magdalena Villarreal? Welcome to court, Ms. Villarreal. The court marks you present in person. The person to your left is your lawyer. These are temporary orders.
Yes, Your Honor. Judge, if I may, on this matter, Your Honor, we had filed a motion for citation by publication, Judge. I don't believe that the order had been signed yet, Your Honor, so we were just waiting on that. That way we could submit that to publication, Your Honor, and then give notice to any unknown father.
I don't have that in my review. Is there a request for substituted service or publication?
There is a request. There is a request on the petition, Your Honor, but there is no motion that was filed with the proposed order.
Oh, so it's just,
Believe I had submitted an order as well, Judge, but if not, Your Honor, I can submit the motion and order separately. And that way it can be granted, Your Honor.
Yeah, I guess I'm gonna have to review if it's embedded within the petition. I need to see if it's sufficient or not sufficient to grant the request. I guess for all of this, Ms. Flores, give us another temporary order setting. This is just the first one.
That's fine. For temporary orders, that will be April 16th at 2 p.m.
All right, so
I can go ahead and submit the motion on its own, the order on its own, Judge.
yeah, I think that would be the safest thing, because if not, I mean, so you'll have an answer. If it's all good, then I'll sign off on the order and there went that. But
Yeah,
if
sure.
there isn't,
And if Your Honor would like, I could put up some testimony, Judge. That way it would supplement the motion once submitted and make it easier to sign.
just put it all in writing.
Yes, sir.
That way it's part of the physical record.
Yes, Judge. And I believe I did submit an affidavit as to that motion, Your
Okay.
Honor, to the, why we're requesting that, Judge. And there should be an affidavit attached. Not sure if that shows on the.
Yes, there is an affidavit that was filed with the motion for temporary orders.
Okay, very good. So I will review that. If you want to file anything just to make it concrete, go ahead. But if it's sufficient, I'll sign off on. We'll come back on April the 16th at 2. Ms. Villarreal, do you have any questions for the court? I wish you well. Good luck.
Thank you, Judge. Judge, that's all I have this morning.
It's
Member
good to
Chu.
see you. Have a great day.
Thank you, Judge.
Next in person, Council Nathan Chu, page 1, number 2.
This is Roy Alexander Guerrero versus Alejandra Baby Guerrero, cause number 2026 FLA 380C3. Good morning, Mr. Chu.
Good morning, Judge. Nathan Chu present for Ms. Alejandra Baby Guerrero.
Court marks you present in person. Good morning, Mr. Garcia.
Good morning, Your Honor.
Court marks you present by video conference. Are you Alejandra Guerrero?
Yes.
Welcome to court, Ms. Guerrero. The court marks you present in person. The person to your left is your lawyer. Unmute your device and tell the court, are you Roy Guerrero?
Yes, Your Honor.
Welcome to court, Mr. Guerrero. The court marks you present. You're participating by video conference. Right, the court has signed off on that temporary order, and I've written in language that says I signed it in open court on the record after hearing non-objection to it. So we'll come back to court on these competing TROs and temporary orders on
April 7th at 1:45.
All right. So between now and then, Mr. Garcia and Mr. Chu, please talk to each other. I guess let me ask you this, because you're both asking for the same thing, but in opposite directions, I guess. Mr. Garcia, how many children before the court?
It's one, Judge.
Morning, Your Honor.
Age,
Two and a half, Your Honor.
gender.
Male.
All true and correct, Mr. Garcia?
Yes, Your Honor.
All right. Gives me a frame of reference, notes to go on. In case there isn't an agreement, I can at least have this information. Anything else to put on the record, Mr. Chu?
Nothing further, Judge.
Mr. Garcia?
Nothing, Your Honor.
Mr. Guerrero and Mrs. Guerrero, keep in contact with your lawyers. They're going to prepare you for your hearing on April the 7th at 1:45. Ms. Guerrero, do you have any questions for the court?
No.
Mr. Guerrero, do you have any questions?
Yes, Your Honor. I haven't seen my son since December 31st. With the temporary order case that's going to go on April 7th, 1:45 p.m. Around what time frame would I be able to see my son?
A question that is impossible to answer at this juncture because it's mandatory that the lawyers talk, and the lawyers, Mr. Garcia and Mr. Chu, they're very well versed in family law. So once they hear from you and once they hear from Ms. Guerrero, they're going to know more or less where this case lies and what the court can do based on your situation. I have no idea who you are, who your wife is, or what your situation is, or what the facts are in the case, but the lawyers do through you. So they're going to be able to give you a window of what the court is likely to do. If both you and Ms. Guerrero agree to that or something very similar, then I won't have to listen to any evidence because you'll reach an agreement with Ms. Guerrero. If you don't agree with whatever proposal is made, then I'll listen to you and Ms. Guerrero and your stories while you get placed under oath. And then based on what you tell the court, based on the evidence and testimony, I'll make a decision. But without knowing the facts in your case, impossible to say what's likely to happen. But the best thing I can tell you is keep in contact with your lawyer. Ms. Guerrero is going to do the same thing. They'll talk to each other, they'll negotiate, and then you'll take it from there. Do you have any other questions for the court, Mr. Guerrero?
No, Your Honor. Thank you very much.
All right, I wish you, Ms. Guerrero, and your son all the best. Good luck.
Those
Thank you,
are all the
Judge.
matters for Council Chu this morning and also for Council Garcia this morning.
Good to see you both. Have a great day.
Thank you,
Yes.
Judge.
Next online is Council Madeline Lopez Escoto, page 2, number 3.
Ricardo Gallardo Soto versus Clarissa Yvette Gallardo, cause number 2026 FLA 401C3. Good morning, Mrs. Soto.
Good morning, Judge. Nice to see you.
Likewise, court marks you present. You're participating by video conference. Ricardo Soto, Clarissa Gallardo. Any parties present?
Identified in virtual courtroom.
Please unmute your device and tell the court, are you Ricardo Gallardo Soto?
No.
That's because I'm not talking to you, Ms. Gallardo. Give me one second. I'll ask you in a second, but you're the respondent. Let me ask the petitioner first. Mr. Gallardo, please unmute your device.
Okay, it's done.
Are you Ricardo Soto?
Yes,
Welcome to court, Mr. Soto. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by Zoom. Are you Clarissa Yvette Gallardo?
Yes.
Welcome to court, Ms. Gallardo. The court marks you present. You're participating by video conference. Ms. Gallardo, you were served with this case on March the 20th, 2026. Do you have
Yes.
a lawyer?
I'm gonna get a lawyer.
Are you asking for time to look for a
Yes.
lawyer, talk to a lawyer, and hire a lawyer?
Yes.
Mrs. Cotto?
That is correct, Judge. She contacted my office. I had sent her a proposal and she indicated that she would hire an attorney. And so we'd ask the court for the next available setting. If she can just let her attorney know to contact me and I'll send the proposal directly to that person.
Understood. Ms. Flores, does the court have Ms. Gallardo's email address?
No, Your Honor.
Ms. Gallardo, what is your email address?
Gallardo.clarissa@yahoo.com.
I don't want to presume that there's only one way to spell Clarissa Gallardo. Spell it out for us, please, slowly, so that we have
GALLARDO dot CLARISSA@yahoo.com.
All right, so be on the lookout for your emails because
Mhm.
between now and the time that you hire a lawyer, and
Mhm.
even the lawyer has to file something in the case, between now and then, if the court needs to send you any information, any notices, any orders, it's going to go to that email address. Likewise,
Okay.
if Mrs. Cotto, on behalf of her client, needs to send you any information requests, she can do that to that email address until the time you hire a lawyer. Between now and
Yes.
then, you're able to communicate with her. Ms. Flores, give us another temporary orders setting, please.
April 16th at 2 p.m.
Now, Ms. Gallardo, I can't impress on you how important it is to look for some person as soon as possible because
Yes.
whoever you hire, no matter who that person is, they're going to need as much time as possible to talk to you, advise you, to learn the facts of your case and your situation, and then to prepare you for your hearing. And then on top of that, they need sufficient time to reach out to Mrs. Cotto because it's very possible, like you heard in the last case, it's very possible that once lawyers that practice family law talk to each other, they know more or less after hearing your stories, your facts, and your history, more or less what the court is able to do. So they can
Yes.
usually reach some agreements on many things, and then anything you don't agree with, I will hear evidence on. Do you understand all this?
Yes.
Do you have any questions for the court?
No, not Your Honor.
Mr. Soto, do you have any questions for the court?
no,
All right, both of you
No
keep in
questions.
contact with your current and future lawyers. Anything else on this case, Mrs. Cotto?
Nothing, Judge, if the parties may be excused.
Yes, Mr. and Mrs. Gallardo, I wish you both very well. Have a good day.
thank you for your time.
Page 2, number 5.
Claudia Lorena Guzman versus James Philip Guzman, cause number 2026 FLA 450C3. Let me say that one more time for the record. 2026 FLA 450C3. Court marks Mrs. Cotto, present and participating by video conference. Are you Claudia Lorena Guzman?
Yes, Your Honor.
Welcome to court, Ms. Guzman. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by Zoom. Are you James Philip Guzman?
Yes, Your Honor.
Welcome to court, Mr. Guzman. The court marks you present by video conference. The court sees that you were served with this about 6 days ago on March the 25th. Mr. Guzman, do you have a lawyer?
I do not.
Will you be going forward today without a lawyer, or will you be looking to hire a lawyer?
I'll be going forward without a lawyer.
Court marks you self-represented. This is a temporary order setting. Mrs. Cotto, go ahead.
Good afternoon. Good morning again, Judge Madeline Escoto for Ms. Guzman, Judge. I had sent Mr. Guzman, Judge, a settlement offer. From my understanding, he's not in agreement with the morality clause. Is that correct, Mr. Guzman?
I'm sorry, the what?
That you're not in that I sent you a settlement offer that you received, correct?
Yes, ma'am.
Okay, and that you're not in agreement with the provision having to deal with other people that you're having an intimate dating relationship with around your children. Is that correct?
No, that's not correct anymore.
Okay, you're in agreement with that?
Yes, ma'am.
Oh, so which part of the, if I may, Judge, so we can streamline this for you, which part of the agreement or the proposal that was sent to you are you not in agreement with?
After reviewing the latest agreement last night, I'm in full agreement.
Okay, so then let me put it on the record because I didn't receive, Judge. I'm sorry, Mr.
I emailed you. Yeah, I apologize.
It's okay, Mr. Guzman. You can email it to me later on today and we'll just attach it to the temporary orders if we can have them both sworn in, Judge.
Mr. and Mrs. Guzman, let me ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Ms. Guzman?
Yes, Your Honor.
Both have answered yes. You may lower your hands one witness at a time. Mrs. Cotton.
So what I will do, Judge, is just to make it easier for the court, let me just read into the record the agreement and then I'll ask questions of both sides. If that pleases the court?
Sure, yes.
Okay. The agreement is as follows. The parties have agreed to a temporary mutual injunction pursuant to the Webb County standing orders. In particular, both parties are prohibited from permitting an unrelated adult with whom they're having an intimate dating relationship with to remain in the same residence with the minor children, be introduced to the minor children, or be in the presence of the minor children at any time until further orders of the court. The parties are in agreement that they be both appointed temporary joint managing conservators with Ms. Guzman having the exclusive right to determine the residence of the minor children, and she'll have the sole right to enroll them in school and apply or renew for their passports. Mr. Guzman will be temporarily awarded possession of the minor children as follows, given that he is in the Houston area. 1 weekend a month, beginning on a Friday at 6 and ending on a Sunday at 6. Mr. Guzman will provide Ms. Guzman a 2-week advance notice of which weekend he intends to have possession of the minor children. The exchanges will occur here in Laredo. The communications with the minor children for the parent not in possession will be on a daily basis by FaceTime or telephone, and they're going to be done through the kids' iPads. The parties will communicate with regards to any issue involving the best interests of their children via text, and all the communications will be with regards to scheduling of any intended visits. And the parents have agreed to not to use the children as intermediaries to schedule any visits. Mr. Guzman has agreed to pay temporary child support in the amount of $1,069 beginning on April 1st and monthly thereafter on the 1st of each month until further orders of this court. An employer withholding will be issued. Ms. Guzman is requesting that you order that she maintain the children under the health and dental insurance through her employment at no cost to her. Any unreimbursed healthcare expenses will be divided 50-50. The parties are requesting that the court award Ms. Guzman a residence located at 2718 Garfield Street in Laredo. Mr. Guzman will likewise have possession of a Chevy Tahoe. Ms. Guzman is requesting that you award her the following debts: her credit cards and debts in her name, her cell phone, and the monthly lease and utilities associated with the Garfield address. Mr. Guzman is likewise requesting that he be awarded the monthly car insurance on his Tahoe, his credit cards and debts, as well as his cell phone. The parties have already filed their 2025 joint return and divided that refund 50-50. And so if I may ask Ms. Guzman some questions, Judge.
Go ahead.
Ms. Guzman, you heard the good morning, ma'am.
Good morning.
You heard the agreement that was placed on the record, is that correct?
Yes, ma'am.
And after several proposals with Mr. Guzman, the provisions having to deal with your children are in their best interest, correct?
Yes, ma'am.
And you want the court to approve the same?
Yes.
And with regards to the temporary division of these assets and debts that we have agreed with Mr. Guzman, you're asking that the court approve the same until the final hearing in June, correct?
Yes, ma'am.
Okay. And do you have any questions for me or for the judge, Ms. Guzman? You understood everything?
Yes, I've understood everything. I don't have any questions at the moment.
Likewise, Mr. Guzman, good morning, sir.
Good morning, ma'am.
Mr. Guzman, you understood that by me sending you these proposals that I was not your attorney, correct?
Yes, ma'am. But
And that
thank you for explaining it.
Okay, and that I've not given you any legal advice,
Yes, ma'am.
correct?
Yes, ma'am.
And you're in agreement with the proposal as I've read it into the record this morning, is that correct?
Yes, ma'am. It's best for the kids. Yes.
And that is in the best interest of your two children that are ages 10 and 6, correct?
Yes.
And with regards to the division of the assets temporarily, until further orders of the court, you will abide by those, by the agreement, correct?
Yes, ma'am.
Okay. All right, nothing further, Judge.
Excuse me, a couple of things. I've now heard from both of you. I heard from you, Mr. Guzman, that you believe that this agreement that you have with Ms. Guzman is, quote, best for the kids. Mr. Guzman, have you entered into this agreement freely and voluntarily?
Yes, yes, Your Honor.
Did anybody force you to enter into this agreement?
No, Your Honor.
All right. Mrs. Cotto, and I heard from Mr. Guzman briefly about the children, but just so that we're clear, how many children before the court?
2, Judge,
Ages
10 and 6, I believe.
and genders.
A boy and a girl.
10-year-old being the...
Boy.
The boy.
All right. Is all this true and correct, Mr. Guzman?
Yes, yes, Your Honor.
Is all this true and correct, Mrs. Guzman?
Yes, Your Honor.
And do you believe that this agreement is in the best interest of your children, Mrs. Guzman?
Yes, Your Honor.
All right. Ms. Guzman, Mr. Guzman, the court has heard your agreement on the record. It's now a legally binding and enforceable order. The court finds that your agreement was entered into by both freely and voluntarily and done in the best interest. And the court finds that it is in the best interest of your son and daughter. So ordered. These are the orders of the court. The orders are due to the court on or before
April 27th at noon by submission.
So, Ms. Escoto, Mr. Guzman, Ms. Flores, does the court have Mr. Guzman's email address?
Yes, Your Honor, but if you can just please repeat the email.
Remind the court what your email address is, Mr. Guzman.
Yes, you can reach me at Jimmy, Jimmy, Guzman, Guzman, 81@gmail.com.
Is that the email that we have?
Yes, Your Honor, thank
All
you.
right, so be on the lookout for your email, Mr. Guzman. If the court needs to send you any information, any notices, any orders, it'll go to that email address. Mrs. Cotto could and is likely to do the same thing. She can send you the proposed orders. You'll receive them there. You'll review them, send them back. I will sign them as soon as they come in, and then Mr. Guzman and Ms. Guzman, you'll work under those temporary orders until you come back on June the 18th at 9 a.m. Mrs. Guzman, do you have any questions for the court?
No, Your Honor.
Same question to you, Mrs. Guzman. Any questions?
No, Your Honor.
All right. I wish you both very well, and I wish your son and daughter all the best. You're excused.
Thank you, Judge. If Mr. Guzman can just sign the agreement, Judge, that way I can just attach it as an Exhibit A to the temporary orders. That would be great.
Sure. So just You've already agreed to it on the record. Just do it physically too, send it back, and it'll be part of the court record. Any questions on this, Mr. Guzman?
No, so you want me to print it, sign it, and then scan it to you?
Yes, Judge Wood.
Yes,
Uh,
that,
Yes,
that
Mr.
way,
Guzman.
there's not only, there's a physical record and also an electronic record of everything that's happened.
Yes, yeah, I was just curious to see if there's a DocuSign or anything like that.
It's on PDF, sir. Yes, there is.
All right, thank you.
All right,
Thank you.
Ms. Guzman, Mr. Guzman, good luck to you both. You're
Thanks.
excused.
Thank you. Thank you, Judge. I have 2 PM cases, Judge, so I'm gonna stay on.
All right,
Thank you, Judge.
thank you.
In-person, it's page 2, number 4.
Manuel Torres versus Kimberly Sanchez, cause number 2026 FLA 409C3. Good morning, Mr. Reyes.
Good morning, Judge.
Court
Judge,
martial
they're
present in
both here
person.
present in-
Pull up in front of a microphone and tell the court, are you Manuel Torres?
Yes, sir.
Welcome to court, Mr. Torres, the court martial present in person. The person to your left is your lawyer. Are you Kimberly Sanchez?
Yes.
Welcome to court, Ms. Sanchez, the court martial present in person. Ms. Sanchez, do you have a lawyer?
No, no tengo un abogado.
No, I do not have an attorney.
Will you be going forward today without a lawyer and representing yourself, or are you asking the court for time to hire a lawyer?
El día de hoy me voy a representar yo misma. Creo que ya llegamos a un acuerdo, so creo que voy a seguir.
Today, I will be representing myself. I believe that we have come to an agreement.
Court marks you self-represented. The court will hear from Mr. Reyes much slower than normal to allow for interpretation.
Yes, sir. Judge, prior to coming up here before you, we had an opportunity to sit down, all three of us, and talk about the temporary orders that are now pending before the court. Specifically, Judge, with regard to child support, my client has agreed to pay the respondent $125 weekly for child support. The child is enrolled in daycare. And it costs approximately $150 a week. And my client will contribute $75 towards the daycare. Also, my client has further agreed to pitch in another $50 for basic necessities, miscellaneous items that may be needed by the child. With regard to conservatorship, the parties will be named joint managing conservators. My client will be receive a standard visitation for a child under the age of 3, Judge, no overnight stay. And with regard to temporary use of property, Judge, there is a home at 603 River Hill Drive. And the respondent, Judge, will continue to be in possession of that home pending the finality of the divorce. There is a note on that property, Judge, and she will continue to service the note. Ms. Sanchez, that is. And Judge, that property was separate property and will continue to be separate property
Owned
And-
by Mrs.
by Ms. Sanchez. Yes.
Understood.
And at the end of the divorce, Judge, we'll probably make a confirmation that it is her separate property. She will have use of the 2008 Silverado pickup. She will also make use of a 2015 Malibu Chevrolet. The child is presently insured through Ms. Sanchez's employer, and she will continue to maintain that insurance. Sounds like it's a group insurance, Judge, that is not gonna involve any other expenses in that regard. Mr. Torres will have use of his Ford Fusion 2014. They'll both be entitled to their personal property, Judge, whatever they have in their possession. Also, the parties will make use of whatever money or bank accounts they have under their name. And that is basically the extent of it.
I guess I can confirm this, but Mr. Reyes, how many, I think I heard, I just want to clarify it. How many children before the court?
One child, Judge.
Age
She's a 1-year-old, Judge.
and gender is female.
Yes, that's correct.
Mr. Torres, Ms. Sanchez, please raise your right hands. Did each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Only true.
Yes.
Both have
May I
answered yes.
proceed, Judge? Miss,
Yes.
and Ms. Sanchez, Judge.
You may lower your hand.
Ms. Sanchez, will you state your name for the record?
Es Kimberly Natasha Sánchez.
Kimberly Natasha Sanchez.
Ms. Sanchez, before coming up here, we had an opportunity to sit and talk about the announcement that was just made to the court.
Es correcto.
Correct.
And that agreement that has been announced was reached between you and Mr. Torres and myself.
Sí, correcto.
Yes, correct.
And I know you were asked already, but you are specifically aware that you have the right to hire a lawyer if you so wish.
Preferiría seguir por el momento representándome.
At the moment, I would like to continue representing myself.
Right. And because you want to represent yourself at this point, you decided to talk to us and reach the agreement that we've announced.
Sí, correcto.
Yes, correct.
And the agreement was reached voluntarily without any pressure or threat on our part.
Correcto.
Correct.
Okay, and you're asking the judge to approve the agreement as announced. Is that true?
Sí, correcto.
Yes, correct.
I'll ask Mr. Torres a few questions, Judge.
Go
Mr.
ahead.
Torres, would you state your name for the record?
Manuel Enrique Torres, recibo.
Mr. Torres, we need an interpreter for him too. Mr. Torres, you had an opportunity to sit with me and Ms. Sanchez and reach the agreement that we've announced to the court.
Señor Torres, usted tuvo la oportunidad de sentarse conmigo y con la señora Sánchez para llegar al acuerdo al cual estamos dictando ante el tribunal.
It's correct.
It's
And
correct.
and you did it voluntarily as well. Nobody forced you to reach this agreement.
Yes, sir.
Usted lo hizo de manera libre y voluntaria. Nadie le forzó a usted a llegar a este acuerdo.
It's correct.
And you're asking
Es
the
correcto.
court to approve the agreement as we've announced it to the court.
Y usted está pidiéndole a este tribunal que apruebe ese acuerdo al cual hemos anunciado ante el tribunal.
Yes, sir.
That's good.
Ms. Sanchez, anything you want to tell the court?
Señora Sánchez, ¿algo más que guste decirle a este tribunal?
Solamente lo de las restricciones que tenía. No sé si las restricciones se vayan a quitar el día de hoy o ya tengo que esperar.
Just in regards to the restrictions that were in place, I don't know if they will be left to the side after today, or is that going to be?
Judge, she's talking about the temporary orders that were served on her.
Su señoría, ella está hablando sobre las órdenes temporales con las cuales fue citado de manera formal.
Ms. Sanchez, if you're talking about the restrictions about communicating peacefully, not disturbing the peace, and communicating respectfully, those remain in place until this case concludes.
Si usted se refiere a la cláusula en la cual las dos partes tienen que comunicar de manera pacífica y respetuosa, esas cláusulas siguen hasta que se termine este caso.
Were those the restrictions you were talking about?
¿Esas eran las restricciones a las cuales usted se refería?
Sí.
Yes.
Yeah, so continue to abide by those until this case concludes.
Continúe siguiendo esas reglas hasta que concluya este caso.
But they apply to both, to you for Mr. Torres and Mr. Torres for you.
Pero aplica a ambos, de parte de usted al señor Torres y del señor Torres a usted.
The court has heard your agreement and approves it.
El tribunal ha escuchado este acuerdo y se aprueba.
The court finds that the provisions of your agreement regarding your child are in her best interest.
Y este tribunal halla que las provisiones en cuanto a la menor están en el mejor interés de ella.
These are the orders of the court, and the orders are due honor before.
April 27th at noon by submission.
Estas son las órdenes del tribunal, las cuales deberán de ser entregadas antes del 27 de abril.
Ms. Flores, does the court have Ms. Sanchez's email address?
No, Your Honor.
Ms. Sanchez, what is your email address?
¿Cuál es su correo electrónico, señora Sánchez?
Es K3MB3RLY250899
K3MB3RLY250899
Be on the lookout in your emails, Ms. Sanchez.
Esté al tanto de sus correos electrónicos.
If the court needs to send you any information, any orders or notices of setting, it'll go to that email address.
Si el tribunal necesita notificarle a usted de alguna cita o alguna fecha o algo, será ese correo electrónico.
Similarly, Mr. Reyes can send you information and requests to that email address.
De manera similar, el abogado Reyes le podrá mandar a usted información o notificaciones a ese correo electrónico.
Ms. Sanchez and Mr. Torres, you'll come back for your final hearing on June the 16th at 2 p.m.
Ustedes regresarán el día 16 de junio a las 2 de la tarde.
Mr. Torres Castillo, do you have any questions for the court?
Señor Torres Castillo, ¿alguna pregunta para este tribunal?
No, sir.
No, sir.
Ms. Sanchez, do you have any questions for the court?
Señora Sánchez, ¿alguna pregunta para este tribunal?
No.
No.
The court wishes you very well to you both. More importantly, the court wishes your daughter all the best. Good luck.
El tribunal les desea lo mejor a ambos, pero de manera más importante, lo mejor a su hija. Buena suerte.
Thank you very much, sir.
Judge, I have nothing further before the court, may I excuse?
Always good to see you. Have a great day.
Always good to see you.
Thanks.
Have a good day.
Have a good day. That leaves one matter, the contested matter. That's on page 3, case 6. Patricia Ornelas versus Jose de Jesus Ornelas, cause number 2026 FLB 152C3. Court marks Mr. Figueroa present in person, Mr. Ornelas present in person. Let me ask our Sergeant at Arms to bring in Mr. Martinez King and Ms. Ornelas, please. I believe Mr. Ornelas is a Spanish language speaker. Court marks both lawyers present, both parties present. Mr. Martinez King, Mr. Figueroa, what is the announcement?
That we made a settlement offer, we were negotiating. I think it's close to being settled. However, we need a few minutes, I think, to finalize one issue. If we can have 5 minutes, I think.
What is the issue?
The period of time that the petitioner's children have to get out of the house. They want for it to be till the end of the school year. I think that's too much. It can be about 2 months. We can give them 2-3 weeks, maybe a month, so we can move out. Something around there.
I see why you need time. Well taken. The school year ends in about a month and a half, 2 months, and that might be what Mr. Ornelas would deem to be unreasonable. So off you talk. Very good. We'll stand at ease for a few minutes to give you time to talk.
Thank you.
Yes, sir. Or did that mean? Good morning. Court is back in session. We are on the record. This is Patricia Ornelas versus Jose de Jesus Ornelas, cause number 2026. FLB 152C3. Counsel Martinez King and Figueroa are both present in person and as are the parties. Mr. Martinez King, Mr. Figueroa, what is the announcement?
I think we've settled all the issues. We've settled all the issues except the date of they're gonna vacate the premises, children of the petitioner. We're proposing April, the end of April. They're proposing the end of May.
All right, so tell the court the full agreement on the record so it's binding, enforceable, and constitutes a Rule 11.
Yes, Your Honor. We've agreed to the following temporary orders. The parties will have mutual restraining orders. My client will have the use of his 2014 Chevy truck. The petitioner will have her 2016 Jeep. Both of them will be responsible for the payment of all the bills at home based on their ability to pay. I believe that's the complete agreement, except they have agreed also to give use and possession and share the possession together, petitioner and respondent. The only issue before the court is the issue of when petitioner's children will vacate the property. We're proposing April, the end of April. They're proposing the end of May for the reasons of school attendance for the minor children.
May have the parties come up to be sworn in and to confirm that this is the agreement. Mr. Ornelas, let me have you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God?
I do.
Yes.
Both have answered yes. You may lower your hands. Is your true and correct name Patricia Ornelas?
Yes, Your Honor.
Ms. Ornelas, did you hear the agreement that was told to the court by the lawyers?
Yes, I did.
Setting aside the move-out date for, I think it's your adult children and grandchildren.
Especially my grandchildren. They're in school.
Listen to my question.
Okay.
So setting aside the move-out date, is that the full agreement with Mr. Ornelas?
Yes.
Was anything left out?
Excuse me?
Was anything left out of the agreement?
No.
Is there anything you want to change?
No.
Same questions to you, Mr. Ornelas. Is your true and correct name Jose de Jesus Ornelas?
Yes.
Mr. Ornelas, did you hear the agreement that was told to the court by the lawyers?
Yes.
Is that your agreement with Mrs. Ornelas?
Yes.
Was anything left out?
What wasn't understood by me was the date of them moving out.
Right, so set that aside. Nobody has agreed with that. I've not made a decision. But everything else, is everything else your agreement with Mrs. Ornelas?
Yes.
Was anything left out of your agreement?
No.
Is there anything you want to change?
Just the date.
All right. So let me hear some argument and then I will elicit, I guess, some testimony. But, and I guess let me clarify some points. I'll begin with the petitioner's counsel, Mr. Martinez King. There is no dispute that the home in question is marital property, correct?
Correct.
Is that correct, Mr. Figueroa?
That's correct. And there's an additional agreement, if I may.
Oh, you were going to take us off course, but I mean, but go ahead.
The parties have agreed to list the property for sale.
Okay.
With Realtor Martha Wright Martinez. And we're talking about the property at 4619 San Rafael and 4621 San Rafael, Laredo, Webb County, Texas. Two lots on it. And the home is in one of them.
Is that your agreement, Mrs. Ornelas?
Yes, Your Honor.
Is that your agreement, Ms. Ornelas?
Yes.
All right, the court will approve that agreement. Let's get back on course. Let me start again. I don't know where we were at. Mr. Martinez King, any dispute that this home is marital property?
No.
Mr. Figueroa? Court has heard none. Confirmation. Mr. Martinez King, tell the court what legal argument there is to request for an extended period of time, and what the legal basis is, and what by way of evidence would support that position.
So as far as it goes, actual code, there is no code based on that. This is merely a transitionary period for them in a way.
Sure.
They've been tenants at the property since 2012, give or take. And so uprooting them in 30 days is a bit of a stretch for a family of four. So that's the reason they are requesting the additional time. Other than that, they don't have any legal basis.
And when you say that they're tenants, would the facts support the position that they pay rent, or do they live rent free?
They make payments. What the payments are used for, I don't have specifics on, but they do make payments, and those payments are used to upkeep the home.
How much and how frequent are those payments?
This is on a monthly basis, approximately between $600 to $700 a month.
When did those monthly payments start?
They began August of last year.
So from the period of 2012 to August of 2025, there was no payments.
Correct.
What was the basis for the change? What caused it? Why pay in August and not before?
There was a change in financial position of the parties.
Ability to pay. Mr. Martinez. But by the way, none of this is evidence. I'm going to get confirmation whether the facts would support or would not support this. And if there's a dispute, then you'll have to get it into evidence. Right now, it's just background. Mr. Martinez King, the change was just ability to pay?
Also, she's advised us that he wasn't working due to an injury prior to that. And as soon as her son was able to start working, he was able to start.
So ability to pay based on ability to work. Okay. Mr. Figueroa, what, if any, facts would not support those set of circumstances?
I believe there were invitees. They were invited to live there in the property. They're not tenants. They were contributing to the expenses. I don't know how much. I think they started contributing now that my client is not receiving half of the paycheck that the petitioner receives from her employment. They used to work together as janitors. That's evidence as to why my client needs to have the use and possession of the property by the end of April is based on the fact that my client is 74 years old. He's diabetic, suffers from cholesterol. He's had a hip replacement. He has takes medication for prostrate, suffers from anxiety. So he's had a real hard time adjusting, and the way he's been treated, the sooner they leave, the better. I think it's an issue of his health. We hope that whatever period the court gives them to vacate, that they will be more courteous and civil to each other and be more, live at peace. And that way it doesn't inconvenience any of the parties.
Mr. Figueroa, since August of last year, these payments, do you know if they're made to both parties in a joint account, in a separate account? Do you know?
We dispute that there is any payments made by them. They started now that my client is not receiving his paycheck. What she's doing with the full amount, I don't know.
Right, but my question is,
We
The-
dispute any payment, any contributions or any payment of bills by the children.
if there were, do you know where that money would be, what account, or is it cash? Do you know?
No, yeah, I'm not,
All right.
I have no idea.
Okay, and that's fair. Mr. Martinez King, these payments beginning in August, were they to one party, to both parties, and what account?
If I'm not mistaken, the party is making them directly to all the utilities. That's the way that they were asked to be paid out to them, or Ms. Ornelas asked for them to be paid out.
So that's why the amounts would vary if true.
Correct.
All right, so this last set of questions, and if you're comfortable with where this leads, then I'll stop. If not, then you'll elicit testimony. Mr. Martinez King, is there a contract for possession or rental agreement?
No written contract.
The parties that are asking to be excluded from the home, are they parties to this case?
No, Judge.
If this were, and it isn't, if this were an eviction proceeding, and it isn't, how much time, if they lost, do you think a judge or justice of the peace would allow them time to leave?
In an eviction proceeding, generally would be 30 days.
What in this case makes this case different from that type of proceeding?
No difference.
Mhm. Anything to add to these set of factual background and legal parameters, Mr. Figueroa?
None, Your Honor.
It seems to me, Mr. Martinez King and Mr. Figueroa, just based on the facts of the undisputed facts in this case, that Mr. Ornelas and Mrs. Ornelas have the superior right to possession over all other persons, and that either one of them or both jointly could ask for the exclusion of any persons not with a superior right of possession to be excluded. And in this case, Mr. Ornelas is making that request. This is one of those situations where I must do what the law says, even though I may disagree, because I think it's good that children have stability and finish out their school year. If this were a family law case where those children were before the court as parties, then I could see how the court can grant. But if these are persons not before the court, non-parties to this case, their best interest doesn't come into play. And if this were, as noted by Mr. Martinez King, a normal eviction proceeding, 30 days would be reasonable. The question is, what makes this case different? There is no difference because these kids, although courts should act in their best interest, courts that they're before should act in their best interest. They're not before this court. So I can't take that into consideration. So applying the strict black and white letter of the law, this court makes a finding that 30 days is reasonable and necessary. The court finds that that date is April the 30th, 2026. Any thoughts, comments, questions, or objections, Mr. Martinez King?
No, Judge.
Thoughts, comments, questions, or objections, Mr. Figueroa?
None, Your Honor.
These are the orders of the court. These temporary orders are due to the court honor before.
April 27th at noon by submission.
I think that's perfect. Anything else on this case, Mr. Martinez King?
Not on our behalf, Judge.
Mr. Figueroa?
I'll submit a separate order for the realtor, Your Honor, then the temporary order separate.
All right.
Thank you. I have nothing further.
Ms. Ornelas, do you have any questions for the court? Ms. Ornelas, do you have any questions for the court?
No.
I wish you both very well. Have a good week.
Thank
We'll
you so
see you
much.
on June the 3rd for your final hearing. Have a good day.
Thank you, Your Honor.
Mr. Martinez King, Mr. Figueroa, it's good to see you both. Have a good day.
Likewise,
That concludes the family law docket for the morning of March the 31st. The court will continue hearing cases at 2 p.m.